Mr. Harrison, you're up.
Judge Northcutt, good morning, and may it please the court, let me reserve 5 minutes, please, for rebuttal. I'm here this morning on behalf of my clients, Kimberly, John, and Gail Gallagher, but as Mr. Trevena saw fit to sue me personally on his abuse of process claim, I am also a petitioner in this case. The background is pretty straightforward. Mr. Trevena and Kim Gallagher had a brief but volatile personal relationship that ended badly. Mr. Trevena sued Kimberly to recover an engagement ring for partition of a home that they bought jointly and for some other relief. Ms. Gallagher counterclaimed for declaratory relief, asserted various tort claims, asserted a claim for unpaid wages as a de facto employee of Mr. Trevena's law firm, and some other things. Her parents, John and Gail, joined in the counterclaim to recover a $25,000 conditional gift that was made to Mr. Trevena in contemplation of marriage. Mr. Trevena took offense at some of the allegations in the counterclaim, moved to strike them as scandalous. The court denied that motion. He then moved to amend his complaint to add a single new count for abuse of process against the Gallaghers and against me personally, based on those same allegations in our previous pleading.
And based on the letter you sent previous to the litigation.
Based on the letter isn't really germane here because...
Go ahead.
Because our motion was based on the litigation privilege to the extent the abuse of process claim was explicitly based on things in our previous pleading.
Well, then, so are you suggesting that your complaint on certiorari is that the judge should not have allowed the amendment to add the abuse of process claim, correct?
Correct.
It wasn't a denial of a motion to dismiss, etc. And that abuse of process claim points to that letter as the prelude to what then happened with the allegations in your counterclaim.
It does.
So is it the letter pertinent?
Well, we did not explicitly raise the privilege as it related to the letter. We raised the privilege as it related to the abuse of process claim explicitly based on allegations in our pleading.
So you have alleged a privilege. So I don't understand what you're trying to do here. You're trying to get us to quash the order permitting the counterclaim, even though you're not asserting a privilege as to part of the, quash the order permitting the amended complaint, even though you're not asserting a privilege as to one aspect of the allegation.
Yes, exactly.
So how does that work? I mean, we would quash the order and then in part, I don't understand.
I think that the order could be either quashed in part based to the extent the claim is based on what we said in a prior pleading, or it could be quashed in its entirety, and they could have another chance to amend on a limited.
Isn't that more akin to order on a motion to dismiss, which you have not filed?
Certainly could be addressed that way.
Okay. Let me tell you, Mr. Harrison, moving on to another topic. I'm just, again, refreshing myself a few minutes ago, looking over your amended counterclaim. And for the life of me, I can't figure out how many of these allegations in the counterclaim relate to the causes of action in the counterclaim. For instance, Mr. Trevena was involved in yet another strange personal relationship that ended up in lawsuits and media coverage. What does that have to do with any of your causes of action in this case?
We explained how they relate in our counterclaim at paragraphs 30 and 31. Mr. Trevena, of course, is a fairly high-profile criminal defense lawyer. His cases get a lot of attention. His personal life, frankly, gets a lot of attention in the media. And we recounted this stuff because it is our theory that this relationship between Mr. Trevena and Ms. Gallagher was an attempt by Mr. Trevena to sort of rehabilitate his reputation in the community on the
and that relates to your causes of action. How is that actionable?
It's not per se actionable in itself, but it provides background and context and provides a theory of our case.
Counsel, that what you're talking about is what the purpose of opening statements are for. It's what the purpose of having an evidentiary hearing is for. It's what you lay out perhaps in a motion for summary judgment. I will tell you candidly, to echo Judge Northcote's point, some of what I read of those allegations read more like a press release than they read like an actual pleading. I mean, the purpose of a pleading is simply to state the ultimate facts that relate to recognized elements of legal causes of action. They should fit together. You need to plead the facts that are necessary in order to support your Florida's fact-based pleading standard, but that's it. I'm not seeing, and I looked through all the different causes of action you've asserted, I'm not seeing how a number of these really have anything to do with anything other than to set forth the very thing that you're talking about, which is generating press coverage.
Or to make good on what could be perceived as a threat in your letter, to basically drag Mr. Trevena through the mud in public if you don't settle the case. I mean, that's how Mr. Trevena has alleged it to be in his.
They certainly allege that, but of course they had previously threatened to file suit before I ever sent that letter, and that's covered as well.
And they did file suit, but they didn't make these kind of, I will use the term scandalous allegations.
Well, sure. Why would they? Again,
why would they? Indeed. And they're just suing. They sued about a ring and about the house. And
right.
The allegations seem to be limited to matters that are pertinent to those areas of inquiry, as the case law describes it.
Well, certainly a pleading has to include, as Judge Lucas has suggested, the essential elements of whatever claims you're bringing. But complaints often, customarily include pertinent background allegations. I don't think I've ever drafted a complaint.
Well, but I think that's the question, though, is how is, Mr. Trevena's, how is any of this pertinent? I mean,
again, it's pertinent because our theory of the case is that the relationship was essentially a ruse. It was an attempt to rehabilitate his public persona, and we say that in our pleading. Now, I understand why he doesn't like that. I understand why he takes offense at that, but the litigation privilege protects our right to say it. And the standard of being related to the proceeding is an extraordinarily low bar. It is such a low bar.
Indeed, Mr. Harrison, it is.
It's such a low bar that no courts ever got there. It's not a strict relevancy test in the evidentiary.
Well, I'm not sure you can say that's true either. You might not have found a reported case. That doesn't mean no court has got there.
Well, I'll stand corrected. We have not found any such reported case, and I did look, and they haven't found any such reported case, and I'm confident they looked. So it is a very low bar, not a relevancy test in the evidentiary sense. The cases are clear about that. That's still Monaco. And Judge Nortwood, in a concurring opinion in the James case, talked about this at some length and said this some relation test requires only a minimal possibility of pertinence or simplest rationality.
I hear what you're saying, and to some degree, what you're arguing highlights something of a tension between what is permissible pleading practice, litigation privilege, whether, you know, what an appropriate standard of relevance or relatedness is. But there's also baked into this Rule 1.140F, which does allow a trial court to strike scandalous or impertinent matters, which, at least to my mind, seems to be something of an intrusion on this, almost what you're almost saying is a nearly absolute litigation privilege to put out anything short of, well, I mean, not even short of defamation. Where do you draw the line? How does a court replicate a standard under the lights of your argument, where, hey, listen, there's a line somewhere, but it's pretty low, you know, the low bar? How does one set the low bar?
Well, I'm not sure. I do know that the trial court did
That's
consider.
a problem, isn't it?
Well, the trial court considered the motion to strike these allegations as scandalous under 1.140F and denied that motion. So at least the trial court,
But then permitted the amendment to allege the abuse of process.
yes. And we don't know why the court permitted the amendment, because there was no hearing, because they requested that the court rule without a hearing under an administrative process that's available in the Sixth Circuit. So when they moved to amend, they asked the court to rule without a hearing. We filed a written response, raised privilege and some other things, and the court then just issued an order. So we don't know the reasoning of the trial court.
Well, maybe that goes to one of the points in certiorari. I mean, let me ask you, what is the irreparable harm of requiring you or your clients to file a motion to dismiss in response to the amended complaint as filed?
Well,
where's the
that's
irreparable harm in that?
the irreparable harm. That's an easy one. The irreparable harm is the litigation privilege is an immunity from suit, and case after case says that being required to litigate where the privilege applies is itself irreparable
Yeah,
harm.
but your point of entry to challenge that is simply you file a motion to dismiss. And then you have the hearing that you're complaining that you didn't get.
Well, but that runs up against another line of cases that says where the issue is immunity from suit, the parties should raise that and the court should decide it at the earliest possible stage of the proceedings. So,
but you are not alleging, you know, the problem is that you are alleging, you are wanting, when you say that you're not alleging an immunity or privilege regarding the letter, which has been alleged as part of this amended complaint. How are we going to, you know, so how are we going to accomplish that? We would leave the amended complaint standing, but just with everything other than the letter stricken. I don't know how that works if you don't file a motion to dismiss and get the court to make that kind of a ruling.
well, again, I think that because the claim based on what's in our previous pleading would be barred by the privilege, this court can make that ruling and quash the order. If they think there is some piece of their claim that would be outside of the privilege, they can certainly try again on another motion to amend. But what they say is our claim is based on these however many paragraphs of the amended counterclaim that they didn't care for. And those things are clearly covered by the privilege. And we're obligated under the law to raise it at the earliest possible time. And we did. It's the privilege in this context is treated as a form of futility. Futility is always grounds to deny leave to amend. And we cite the cases that treat the immunity as a form of futility. If it's a form of futility that's grounds to deny leave to amend, then it necessarily follows that we have to be able to raise it at the leave to amend stage. Otherwise, it doesn't make any sense. So we did. That doesn't mean it can't be raised later. It means we're obligated to raise it as soon as possible, and we shouldn't have to litigate a case for a day or a moment or a dollar longer than is necessary where the privilege applies.
Mr. Harrison, I was just reviewing, you referred a few minutes ago to Judge Van Nortwick's concurring opinion in the James case of the first DCA. And I want to read you a couple of sentences of the last paragraph, kind of suggests to me the situation we're in now. And that was a case where there was a trespass action, and this fellow represented himself. And in the case, quote, that his lawyer submitted a declaration that the defendant was, quote, reported to be fond of sheep, bucks, and ewes, and of wool, mutton, and lambs, and was in the habit of biting sheep, and if liable should be hanged or shot. And when he was sued for libel, the lawyer asserted the litigation privilege, and the court rejected it. And Judge Van Nortwick is describing this as with approval. The court found that the lawyer's statement in no respect was relevant or material to the underlying action. And although you have contended in your briefing that because you alleged it in your complaint, it was absolutely immune. But Judge Van Nortwick says, no, that's not true. If there's if it's in no respect relevant or material, and although you're describing some theory of the case, frankly, I'm having trouble seeing it. You are, and we are. By the way, we've helped you get to your rebuttal time. So I'll give you the 5 minutes if you want to save them now or keep talking. It's totally up to you.
Well, let me just respond to your last question, Your Honor. I'm not sure. I don't have the case in front of me. I'm not sure how the mutton and lamb, how old that case is.
Oh, it's quite old, but Judge Van Nortwick's concurring opinion isn't that old, and you just relied on his recurring.
Right, I understand. But my point is that later cases, including Delmonico, have said it's not a relevancy standard. So we're not talking about relevancy in the evidentiary sense.
You described it as statements bearing no relation to the judicial proceedings, even though they were made in the judicial proceeding.
Right. And we believe that these statements and allegations do pertain, relate closely enough to the proceeding because they provide the context for the background of the case and our theory of the case as alleged. I do want to save my few minutes of rebuttal, so let me go ahead and stop there.
Okay, I'll let you have 3.5 minutes. Okay, Mr. May? You seem to be muted, Mr. May. In fact, you definitely are muted. There you are.
Yes, sorry about that. Thank you. Good morning. May it please the court, Robert May for the respondent, Johnny Trevina. I want to hit on a couple of things that were addressed just at the end of the argument there, that the Nortwick decision and the petitioners claim that the fact that a statement is made during the course of litigation or in a pleading automatically cloaks it in the privilege, the absolute litigation privilege, as Judge Northcutt just pointed out, is rebutted or contradicted by the Nortwick decision. Also, the LATAM case, which is cited extensively by both parties in this case, rejects that. And also one of the cases in the reply brief filed by the petitioners, the James versus Lee case, also contradicts that. And using an extreme example, the Lee case, it's a concurring opinion, but in the concurring opinion, the judge says, well, if in a pleading they say that, the defendant supports Al-Qaeda or has some relationship to Al-Qaeda, that certainly wouldn't be protected even though made in a pleading. So there is a line. I think that the panel's correct that there is a line and there is some requirement that there is a relation to the allegations in the cause of action in order to be cloaked with the absolute litigation privilege. Maybe that line is blurry and ill-defined and there's a dearth of reported cases highlighting the line, but there is a line. And in any event, the trial court should be the one to first explore that line. And briefly, to the claim that the rationale or the relevance of the scandalous allegations to the causes of action are that Mr. Trevena was involved in a 2-year plus long ruse to rehabilitate his tattered reputation is preposterous. Who would go to such lengths just to try to rehabilitate their allegedly questionable character or professional standing? That there was an expensive engagement ring exchange.
Do any of the causes of action, in your view, asserted in the counterclaim require proof of the motive?
No, they don't. So I don't agree that there's any relationship to your point. And it would be quite a ruse if that was the basis for the relationship. It lacks any credibility. But to the legal issues that I think the court is faced with today, the panel's faced with today, I'll try to succinctly get to them. We disagree fundamentally with the petitioners as to when and how the absolute litigation privilege must first be raised at the trial level. Whether the trial court can, in fact, in this case, analyzed and rejected application of the absolute litigation privilege. And I think we've already disposed of this issue, or somewhat in my mind, whether the mere fact that an act occurs during the course of litigation automatically triggers application of the absolute litigation privilege, which we disagree with. And these distinctions are critical because the trial court should determine and make some kind of findings. And in this case, we have an unelaborated order. And I don't know if it's because we didn't want a hearing. A lot of times when you try to seek a hearing in the 6th Judicial Circuit, the JA will say the judge will consider this on written submissions only. So I don't know if we actually tried to get a hearing or not, but the result is we have an unelaborated order that simply says our motion for leave to amend is granted and that the defendant has 20 days to file an answer. And that's it. And we're left to guess as to whether the court actually considered the litigation privilege, or if the court just considered the very liberal standard of granting leave to amend and didn't really consider the litigation privilege. And that's really where the crux of the disagreement comes into, is that the petitioners want this panel to believe that the court reviewed and rejected the litigation privilege in the unelaborated order. And I don't think that we can conclude that, and that it was their burden to raise that properly. And in every single case between the petitioner's petition and their reply brief, I think there's something, maybe 25 cases that purportedly stand for the proposition that the court can just rule on a privilege without having to file a motion to dismiss or summary judgment. But that is contradicted by every single case. I looked at every single case, all the state and all the federal, all 20 plus of them, and in every case cited, the issue of the application of the absolute litigation privilege, even when it appears on the face of the complaint, is first tested by a motion to dismiss, and in a few occasions was raised by an affirmative defense and a summary judgment.
Yes, then, Mr. May, assume we do as you are requesting and we deny this petition. Then I assume what will happen next is that the petitioners here will file a motion to dismiss and the lower court will rule on it. And we may end up right back here.
Yes, sir.
Go ahead.
I agree that that is likely going to be the procedure, and that's how it should have happened in the first instance, because this panel should not be doing the initial work on a failure to state a cause of action or application of a privilege that wasn't properly and fully raised. And I think that the slight distinction is, if this gets kicked back to the trial court, is the trial court must make some kind of finding or some analysis of the application of the litigation privilege, either based on the complaint, or if it's raised in an affirmative defense and taking other evidence on a summary judgment. The court is going to be required, because all of the cases cited, the LATAM case and the Delmonico, the primary cases cited by both parties, clearly say that the abuse of process claim persists in Florida, and there must be some relation to the judicial proceedings. And as it stands, there has not been any analysis of the some relation or the relationship. And I agree that the standard's low, but it's still there and it still needs to
Mr.
be
May.
explored.
Mr. May, can I ask a quick question, just a point of curiosity? So this is an amended complaint that you all were filing, and forgive me, because I just don't remember the record procedurally what happened before. Had there been an answer filed to your original complaint? An answer and a counterclaim?
Yeah, I can answer that for you, Judge Lucas. There was an amended answer and counterclaim to the initial complaint, and then
Okay.
what is before us is an order permitting an amendment to the complaint to assert the abuse of process count.
That I got. I just wanted to
Yeah.
make sure that procedurally how that got teed up.
Right.
So,
Go
I'm
ahead.
sorry, go ahead. So, Mr. May, your argument then is that, hey, look, this needs to go the customary route from the prior cases, that this gets considered on a motion to dismiss. Suppose it gets there. Suppose we look at a little bit more of the substance of what's happening here. What if your friend on the other side's argument about, hey, listen, we are entitled to pitch our theory of a case, and our theory of a case is complex and somewhat salacious, but it is what it is, and we have a right to put that out there, and more than that, we have a right to be able to litigate that. What are your thoughts on that position?
Well, as mentioned in the initial statements by Mr. Harrison and the panel's questioning of him, that there is a line somewhere. There is a line, whether it's tested by a 1.140F motion to strike or a motion to dismiss, that I don't believe they're entitled carte blanche to say whatever they want. And the case law bears that out, that there is some kind of check on what you can do and say in litigation to be entitled to application of the absolute litigation privilege. And maybe the trial court goes back and says, you're entitled to some kind of lesser privilege, a qualified privilege, which can be overcome by our showing of express malice. So I think these things have to have taken place for this court to have anything to really look at.
Excuse me. On the other hand, I was going to follow up my last question. You folks have briefed the merits of this issue. Could we decide it in this case, whether you're entitled to proceed?
Whether the absolute litigation privilege applies?
Yeah, on the basis of the record in front of us.
I don't believe so. I know it's a matter of law. The application of a privilege is a matter of law, but I think procedurally the defect still stops it. Because the trial court should have had the first bite at the apple to make a ruling about the application of the litigation privilege before resorting to the extraordinary remedy that has been invoked today. Are there other questions?
There was, though, and we have this in the appendices, or one of the appendices, a motion to file the amended complaint with the allegations in it, and then a response to that motion. Right? I mean, so these arguments appear to have been made of record below. Now, we don't know what the judge considered because the order was unelaborate, but we do have the arguments put forth below, correct?
That's correct. That the litigation privilege, among other failure to state a cause of action, were raised in the motion opposing, or the response opposing the motion for leave to amend. I think this really turns on what the trial court has left the appellate court with. If the trial court had made some kind of findings about the application of the privilege or the reasoning, some elaborated opinion or order, we might be in a different posture in this. But because of the nature of the order, I
I
believe
mean,
this has.
that's an assumption. I mean, this could get teed up on a motion to dismiss, and the court could simply enter another unelaborated order that says motion to dismiss is denied, in which case, back to Judge Northcutt's point, you're right back into the same place again, assuming the other side doesn't wish to withdraw down this hill that it's built up.
Well, I think that this court could direct the trial court to make some kind of findings or make some kind of a record as to the reasoning and rationale for the determination. But at least then there would be an order that was properly before the court. And I think that the standards are different for the motion for leave to amend versus the motion to dismiss or a motion for summary judgment. I think our argument is that we could have properly been granted and were properly granted motion for leave to amend, and we still could have lost on a motion to dismiss, but the trial court didn't get that opportunity to do that. I guess in closing, I don't need to use all my time. So
We don't take points off if you don't use all your time.
very good. I guess I would just say that there has not been any irreparable harm because the petitioners have not availed themselves of all of their remedies at the trial level before resorting to the exceptional remedy that brings us here today. And that there is definitely some line where things that are said during the course of litigation, even in pleadings, are no longer entitled to application of the privilege, and that requires some level of fact-finding or analysis by somebody, whether it's the appellate court or the trial court. I would submit it's the trial court's initial role to do that judicial work before it falls on your plate.
Thank you, Mr. May.
Thank you.
Mr. Harrison, I left you 3.5 minutes of rebuttal.
Yes, Your Honor, thank you. On this question of whether the court could have considered it at leave to amend or has to decide it on a motion to dismiss, and Mr. May just said there needs to be fact-finding. There is no fact-finding. The court is comparing their abuse of process claim, which is in a pleading, and looking to see, is this based on stuff we said in a pleading? And that's the analysis. There is no other fact-finding. The court then decides, does the privilege apply?
So your position is that we can reach the merits of this controversy in this proceeding before us?
I think you can, because that sets up a question of law. There are no facts to be found. They have a complaint, or whether it's a proposed complaint or a complaint that's actually filed. You look at the complaint, they allege abuse of process based on however many paragraphs they're unhappy about. And those are clearly things in our prior pleading. So I don't know what facts need to be found. And I don't think the trial court's analysis is any different, whether it's doing that on a motion for leave to amend, where we raised it as you noted in our response, or whether it's doing it on a motion to dismiss. The trial court's work is identical, irrespective of which point in the process it's raised at. So I think that the answer is yes, the court can reach the merits of it, if that's what it chooses to do. I don't think it is true that the trial court entered an unelaborated order. We don't know explicitly why the court granted leave to amend, but I don't think we can make an assumption that the trial court ignored arguments that were raised below. I think if we're making an assumption, the assumption has to be that the court considered that in good faith and made a decision. I would certainly not want to suggest that the trial court ignored arguments that were presented to it. And again, the only difference that I see between doing it at that stage and addressing it on a motion to dismiss would be that I suspect there would be a hearing on a motion to dismiss, which there was not here. But the only reason there was no hearing in this case is because they asked for there not to be a hearing. So I do think, I don't see any distinction in what the trial court would have done, whether it did it on leave to amend or on a motion to dismiss. The legal standard and analysis is identical.
Okay, anything else?
And that's all we have on rebuttal, Judge. Thank you, unless there are questions.
All right, thank you both very much. In order to leave our virtual courtroom, there is a button on your Zoom screen. It's on mine, it's in the lower right. It's red, it says leave. And if you click that, you will leave.
Thank you for your time.
Thank you, Your Honors.
Go. All right, our next case is NCWPCS MPL. It's et al.